Hi, everybody. Thanks for joining me. Thanks for joining the Chamber's second virtual fireside chat with today we have Marcia McNeil, who's a local employment law specialist and a lawyer with Pulver Crawford Monroe here in Victoria. And we know that there are many employers out there who have had a remarkable number of questions with regard to how this strange experience of the pandemic is affecting their workplace and their responsibilities as an employer to their employees. So Marcia has agreed to join us and have a conversation. I'll ask her some questions about what she's hearing, and we'll get some excellent professional advice from her. So welcome, Marcia.
Thank you very much.
Thanks for joining us. So my first question is that we're in this extraordinary circumstance. We're in this extraordinary circumstance where government decisions about public health are having this huge impact on employers. So what are the main things that you're hearing from employers?
The three questions, or the three areas where the questions we're getting from employers are primarily arising. First and foremost have to do with layoffs and the need to lay off staff as a result either of a government closure, government directed closure, or because business has simply reduced significantly to a point where layoffs are necessary. That has been the majority of the calls we've been receiving over the last number of weeks, but we're also getting a number of calls from employers trying to understand the various benefits that have been introduced both provincially and federally, both for their employees and for employers, the wage subsidy in particular for employers, to try and understand whether they qualify or not. And unfortunately, that's a changing landscape. So every day we're getting a little bit new information about those benefits and those programs. And by and large, the information we're getting is good, meaning that the programs are being expanded, not contracted. But there's still not perfect clarity on most of those programs. And finally, and perhaps to a lesser degree recently, we're getting questions about those workplaces that are still in operation where people are still physically going to a work site rather than working from home. What kind of obligations employers have to ensure that their employees are safe in the workplace.
Yeah. So maybe picking up on a couple of those, what are you telling them about their obligations with regard to their work site?
Well, I usually start by saying the answer I would have given 3 months ago is a little bit different than the answer I'm going to give today. 3 months ago, what I would have said to any employer looking at what's effectively a temporary layoff of, and I'm going to be speaking about non-union staff, the rules are obviously different in the unionized sector, but with non-union staff, by and large, there is not really a right or opportunity for most employers to lay off their staff. And by layoff, I mean a temporary layoff where the employment relationship continues, but the employee isn't working for a period of time because of a shortage of work. Even though there's a reference to layoffs in the Employment Standards Act, the Act has been interpreted to mean that most employers don't actually have the right to lay their staff off, and that a layoff constitutes effectively a constructive dismissal of the employment relationship. It's a unilateral change in the terms and conditions by the employer, triggering the employer's obligations to give notice or severance. What's different about that currently are two key things. First and foremost, employees always have a right to agree to be laid off. And in the current economic climate, many employees would prefer to be laid off and maintain an employment relationship than accept severance and have the employment relationship come to an end. And secondly, the Employment Standards Act, and to a certain degree the common law, contains a provision that says that the obligations to provide notice or pay in lieu of notice or severance to employees may be waived in circumstances where there are unforeseen circumstances triggering the layoff. What we have not successfully been able to do is get the Employment Standards Branch to weigh in on whether layoffs arising from COVID constitute unforeseen circumstances that would exempt employers from those obligations under the Act. The Director of Employment Standards has effectively said that he won't give an advance ruling on that. So effectively, at present, and in an event, until the first case is heard by the Employment Standards Branch and they've considered the circumstances, we can't definitively say that that exemption applies. It would appear on its face that it should, but we don't have any prior example to rely on to say whether it does or doesn't apply.
Wow, so that's very murky at the
Yes.
moment, isn't it?
Yes, it is.
Is there a difference between employers that have chosen to close because of lack of business, as you said at the opening remarks, your opening remarks, or those between those and the ones who are obligated to close, ordered to close because government has made a decision, like the one about bars and restaurants,
Right.
that they can't operate?
There are two potential differences. One certainly is we anticipate that those businesses that have been required to close by direction of the public health units and the medical health officer would be in a better position certainly to argue that these were unforeseen circumstances. And so they may have a stronger argument to rely on the exemption in the Employment Standards Act, first and foremost. Secondly, those employers who are laying off staff or reducing staff, terminating staff as a result of a reduction in business, given the new wage subsidy program, if they would have qualified for the 75% wage subsidy that the federal government is offering, they may have a harder time claiming effectively that it's a frustration of contract situation, that the reduction in business caused a frustration of contract, relieving them of their obligation to pay, provide notice or severance to staff. Again, these are all untested arguments, but we anticipate it will be a little bit more challenging for employers that would qualify for that benefit to later argue that they weren't able to pay their employees in the circumstances. So there may be lots of employers in a middle ground who have lost business but don't qualify for the benefit because the benefit may not be as widely cast as is currently necessary. But for those that would qualify for the benefit, we anticipate it will be more challenging to argue that it was circumstances beyond their control caused them to terminate or lay off staff.
So, my layperson's interpretation of what you're saying is they can still, of course, actually choose to terminate their employees and give them the appropriate notice and or severance with regard to that decision. You're just talking about the layoff with absolutely no notice or severance.
That's right.
In these circumstance being the murky area.
Yeah. Employers certainly have every right, if their business is declined substantially or completely, to terminate employees and provide them appropriate notice or pay in lieu of notice severance. Many employers just don't have the opportunity to provide notice, and so they're looking at potentially very substantial severance packages.
Yeah, and a number of employers, that I'm aware of have had to lay off 100, 200 people almost instantly, unexpectedly, and that's an enormous amount of severance to have to deal with if they aren't able to use the layoff provision.
Right. Even taking just the bare minimum Employment Standards Act severance, when there's more than 50 employees laid off or terminated from the same employer within a 2-month period, that starts to increase even the minimum amount of notice or severance. And once we get over 300 employees, in addition to the minimum amount of notice or severance, employers are obligated to provide an additional 16 weeks. So many employers are entitled at minimum to 24 weeks of notice or severance. Over and above the Employment Standards Act severance amounts, of course, are common law severance amounts, which are substantially higher and depend on whether the employee has a contract that specifies how much they're entitled to or is just subject to the normal rules that look at employees' age, years of service, position, and opportunities for reemployment. And on that point, obviously, employees have very slim opportunities for reemployment in the same sector in many cases. And so we also anticipate that severance awards from the courts may increase in reflection on current circumstances.
So paying close attention to the volume of employees that you're dealing with sounds critical as well.
Absolutely.
Okay, so you have talked about this 13-week period that is a de facto layoff period. As you said, it's kind of murky because we're not sure exactly how those unexpected circumstances are going to be defined. But we're going to get to the end of that 13-week period. And what are the obligations of employers at that point?
And in fact, again, I'm going to make a murky area even murkier by saying if an employer doesn't really have a right to lay off at all, then the 13-week period referenced in the Employment Standards Act is also a bit of a misnomer. So either an employer in most circumstances can rely on that exemption from any notice or severance requirements in the Employment Standards Act, the unforeseen circumstances exemption,
Right.
or the notice or severance obligations may be triggered immediately.
Okay.
So the 13 weeks for most employers is really not a bellwether point at all. There are some sectors, construction would be the obvious one, where it is an assumption within that sector that layoffs are a normal part of business,
Yeah.
but most sectors don't have that exemption.
Right. Okay. So we've had a couple of similar questions from employers come in, and I'm going to ask them now.
Okay.
They're concerned that they are keeping their place of business open. A number of businesses have been designated as essential services by the province, and the expectation is they do stay open. Let's pick a grocery store for an example.
Mm-hmm.
And they're concerned that they're feeling that they're responsible to keep that business operating. What happens if an employee is at their workplace and does contract COVID-19, get sick on the job? Where does that leave them, especially if it becomes a very serious illness where they can't come back to work?
This is another area where we'll have to see how the case law evolves. I mean, certainly our first assumption would be that those employees would qualify for WorkSafe benefits if they have contracted COVID in the workplace.
Okay.
There may be some concerns about demonstrating that they contracted COVID in the workplace as opposed to in some other place, but assuming they can make a tie to their workplace, then WorkSafe benefits would apply. So employers who are still open and have employees continuing to interact with the public or interact with each other, meaning they're not working from home, for example, have a responsibility to pay attention to the additional rules that WorkSafe has introduced and the province have introduced about how to ensure employees in those sectors are remaining safe. And as long as employers are following all of the rules and directives, taking all appropriate precautions, all prescribed precautions, the employer's own risk will not be particularly changed. But it is important to make sure that employees are following those directives, that they're using masks if that's appropriate, they're using gloves if that's appropriate, that they're maintaining social distancing as appropriate and as possible, that they're sanitizing areas where members of the public may have touch the surface, a keypad on a bank machine, that kind of thing on a regular basis. So employers do have to be vigilant. They have to make sure that their employees are being vigilant, but it's important just to keep abreast of what WorkSafe is requiring employers in those circumstances to do and make sure you're following those rules and regulations.
Okay. Now the province did pass an amendment to the Employment Standards Act, and it dealt with the issue of employees who are at home. And you, in our discussion before this conversation, you talked about some confusion about how that applies. Could you clarify what that new regulation means?
Sure. And I will say both provincially and for federally regulated employers, very similar provisions were passed. So what I'm about to say by and large applies both to provincially regulated employers and federally regulated employers. Just as our Employment Standards Act recognizes a number of other kinds of leaves, jury leave, maternity leave, a variety of different kinds of leaves, they've now added a COVID leave, and it's a temporary measure only intended to apply during this current pandemic. But it allows employees to take a leave of absence either because they are ill with COVID, because they are required to be at home as a result of an order to self-isolate. For example, if they'd traveled over the March break and are required now to be at home for a quarantine period, or if they're looking after children or children who are no longer have access to school or daycare. or looking after someone who is ill. In all of those circumstances, employers are now required to provide a leave of absence to that employee and to return the employee to their position when that leave of absence would come to its natural end. The area of confusion, though, is it doesn't provide a super right to those employees over other employees. They are to be treated the same as other employees. So if all employees in a workplace are being temporarily laid off or terminated as a result of the pandemic, an employee in that circumstance is not given superior rights to those employees. So if the person's job has become eliminated because of COVID, then they will also be laid off at the end of their leave period. So
regardless of whether they're at home or not. So it can't happen during their leave period. So the leave is protected under legislation now. But you're saying that there was some confusion where employees were saying, as long as I'm at home, you can't apply these other measures to me. You can't terminate me or you can't lay me off. I'm protected because I'm at home.
Yeah, and in fact, in some of those circumstances, an employee who is at home because they have COVID, they are ill themselves, would qualify for their employer's sick leave benefits, or at minimum, the employment insurance sick leave benefits. An employee who's at home to look after a child, where both the employee and the child are well, wouldn't qualify for any benefit. And so they would be entitled to the leave of absence, but it would be an unpaid leave of absence. So that individual may be better off getting their notice or severance, or being laid off and having access to employment insurance or the new CERB benefit, rather than simply being home on a leave of absence without pay. So I think it's important that employees understand what the new provision is intended to do, but what it also doesn't do is give them any guarantee of any kind of compensation.
Income. Yeah, so it protects the job while they're looking after when a valid leave, but it doesn't protect their income.
That's right.
Yeah. Okay, any other, oh, wait a minute, we have another question. So the question is, what about workers that do not have benefits? What about workers who do not have benefits?
So if we're talking about medical, dental benefits, things of that nature, those employees who qualify for the EI illness benefits now can get onto that benefit immediately without a waiting period, and they no longer need to provide any kind of medical note to support the benefit. If they are at home ill, they can immediately apply for the benefit. I'm anticipating there's going to be audit provisions at some point down the road. So it's not recommended that employees just claim to be sick when they're not, but they don't need to produce a medical note, because obviously we don't want individuals going to doctors to get medical notes saying, they have the flu or something else right now.
Yeah.
So they can qualify for those EI medical benefits. In terms of other kinds of benefits, there are no obligations on employers to provide benefits, but if an employer already has a benefit plan in place, then they would continue to have access to those benefits as long as they maintain their employment relationship and as long as they're still paying the premiums for those benefits.
Okay, great. We do have some employers. You made a reference to the federally regulated employers when it comes to this at-home leave new provision. Are there any other? Most of our employers are provincially regulated, but is there anything different for those ones that are federally regulated that they should be aware of?
There are some subtle differences. The Federal Act has a slightly more generous provisions about layoffs, and it does have wider provisions that allow employers to lay off in certain circumstances. But the difficulty is having federal employers shoehorn themselves in, if I can put it that way, into one of the the layoff provisions, because they all assume that the employer will know the length of the layoff. And that's something that certainly does not apply now. Most employers are unable to correctly identify the length of the layoff that's going to occur. So we've posted on our website, we posted a number of things on our website that we hope are guides to employers about various questions, but we've posted one specifically for federally regulated employers about their obligations. And so employers may want to look at that if they've got questions.
Okay, great. We have another question here. What about workers that will make more than what they got paid monthly on the job? Should employers just pay them more?
I'm not certain what that means. Both the CERB benefit may in fact provide some employees with a better wage than they were making.
I think that's what
working.
this is
That may
referring
be the
to.
nature of the question.
Yes.
There's still a lot of questions about that CERB benefit, the Canadian Emergency Response benefit, and how it's going to be applied. Typically, an employee who normally would qualify for EI receives 55% of their wage to a maximum. So an employee typically can't get more than their normal wage while on EI. And up until this week, anyone who qualified for EI was expected to apply for EI and be processed through the normal process. Because the government was a bit concerned, properly so, about the number of applicants they would be receiving this week with the CERB benefit opening up this week. They're now processing all applications as CERB benefits for now, just to make the to make sure there's not a lag in the benefits. And I don't know if anyone noticed, but the CERB benefit opened on Monday, and there were 800,000 applications on Monday, and only 1/4 of eligible applicants were supposed to be applying on Monday. So that suggests that 800,000 people is 1/4 of the eligible applicants for the CERB benefit, which is an astounding figure. So you can imagine the government is flying fast and hard to try and meet the needs of individuals. And as a result of that, it is entirely anticipated that there will be some slippages and some people that fall through the cracks, and the government's trying hard to try and close the gaps where they can. But I anticipate it is possible that someone who doesn't qualify for EI that applies for and is awarded CERB may well receive more income through CERB than they would through their employer. They do have to demonstrate that they haven't been working for 14 days, though, in order to get that particular benefit.
Right. And there are, when you say it's ever evolving kind of project by the federal government, there is now some talk about being able to earn, if your income has been reduced drastically, you can still qualify for CERB. So you get your 2,000, but you can also top it up if you have still got some minimum earnings. Yes. Minimal earnings, because as the Prime Minister said the other day, they're trying to encourage as many people as possible to stay connected to whatever income source they have.
That's right. So there have been proposed amendments to the CERB benefit, and that's exactly what we understand those proposed amendments will do. There also was a bill circulated yesterday to expand the scope of the federal wage subsidy to make it easier for many employers to access who weren't in a position to demonstrate the 30% drop in revenue. Yes. Because of the nature of their business, or if it was a new business that didn't have revenue last year to compare. So they've circulated a bill yesterday that's made 3 amendments to make it easier for employers to access that benefit as well.
Yeah, that was our next question. If your company opened in the past year and you don't have wage info for a year previous, April 2019, how do you qualify for this 75% wage subsidy? And as you just said, I think there's a couple things they've done. They've said you can compare it to January and February of the current year. Yes. And you can, and then on a slightly different note, you only have to demonstrate a 15% decline in revenue from March, because not everybody had the experience of the full impact of the decline in business in March. Anything else I'm forgetting about?
And it got an inclusion that it allows people to use cash accounting, and I won't even begin to explain what that means, but it allows a different method of accounting to demonstrate a loss in revenue. And it appears to be based on employers who send out invoices but have no expectation of receipt in response to those invoices, because the customers are no longer able to pay.
I see. So they maybe are demonstrating that they have presumably earned that revenue, but they're not going to get it because of the current circumstances.
That's how I understand it, but I haven't seen the specific wording yet.
Yeah, and there was also a provision for not-for-profits and charities, wasn't there?
Yeah, there's going to be some allowances made on how the groups of that nature who don't have traditional revenues would be able to demonstrate a sufficient loss in order to claim.
Right, how government funding plays a role in that, for example. So they should pay attention to those exceptions for
Yes.
not-for-profits.
And that's just a bill, so those haven't yet been passed, but I anticipate that's going to be expedited.
Yeah,
Unless it's passed today, and that may be the kind of news that I just haven't been able to
right.
catch
Hard
up
to
with
keep
yet.
up.
Yes,
Hard to
exactly.
keep up, isn't it?
Yep. Yep.
Well, we're out of time, Marcia, so thank you very, very much. I found that very useful myself, and I hope all of our employers who are listening found it equally as useful. As you said, you've got more information posted on your website at Pulver Crawford Monroe, so anyone who is interested in more details needs to go there. And I'd just like to remind everyone who's watching that we have another virtual fireside chat tomorrow with the Honorable Mona Forche, who is the Associate Federal Minister of Finance and Minister for Middle Class Prosperity. And she'll be with us for an hour at 1 o'clock talking about the federal government programs in more detail. So I can follow up some more with her about their current and future intentions.
Great.
So thank you very much, Marcia. And I'm sure you'll remain busy.
Absolutely. You as well.
Yes.
All right.
Yes.
Yeah.
Have a
Thanks.
good day.
You too.
Bye.